name is Morven Douglas and I'm one of the senior associates in the family law team at BTO Solicitors based in our Glasgow office. The team and I have been putting together some video blogs that we think would be useful to those who might be in need of a family lawyer. So today I'm going to look at the question which the majority, if not all, of my separated clients ask, which is how is the law going to divide up our assets now that we have separated? And I'm also going to look at what you can expect from your first meeting with your family lawyer. Today I'm going to focus on this question being asked by those who are spouses or civil partners. It goes without saying that separation and divorce or dissolution is one of the most stressful situations an individual can go through in their lifetime. They are emotionally vulnerable, they're stressed at the loss of their relationship, and they're very scared for the future, their own future, that of their children, and they're really worried about how they're going to manage financially, how they're going to make ends meet, how two households are going to be financed rather than just one. However, the thought of going to a family lawyer can be really daunting for a client. It's the first official step towards recognising that the relationship is at an end and that arrangements are going to have to be put in place for the children and the assets are going to have to be divided up, and that this is all going to become a lot more formal. These fears can put clients off coming along to see a family lawyer, and that can actually create real problems. What often happens is that the stress and fear just grows and grows at home, which will create a pressure cooker which will eventually explode and potentially make a bad situation a lot worse. It's totally understandable that clients are really stressed about coming to see a lawyer. It is really daunting for them, but for our clients, the majority of them will be hugely relieved after their first meeting. They will feel that they have taken some control over the situation. They will see a path through the difficulties, and rather than looking at it in a negative way, they'll look at it in a more positive way, seeing it as bringing to an end a very difficult chapter and moving towards a fresh start. So what will you be asked by your family lawyer at your first meeting? Well, we will ask you how you want your children to be cared for by you and your spouse or civil partner now that you're separated. And in relation to financial matters, we'll ask you for a list of your assets and debts that you held at the date of separation, and that's in your individual names and also in joint names. And that's on the basis that the law that governs the division of assets between spouses and civil partners states that it is the property that existed in joint and sole names at the date of separation that is matrimonial property that requires to be shared between you. There are, of course, some exceptions, such as gifts from third parties, inherited funds, assets purchased prior to the marriage. Similarly, debts that have been accumulated prior to the marriage will not be matrimonial debt unless they have been accumulated in relation to matrimonial property. For example, where parties have perhaps purchased a property before marriage but purchased it as a family home for themselves, thereby rendering it matrimonial property, and they've taken a mortgage out on that property, and that would be matrimonial debt even though it was taken out before marriage. And these exceptions are made by the law because it is based on the underlying principle that it is the fruits of the parties' marriage that should be shared between them, i.e. assets that have been accumulated through their efforts during the marriage. When we're talking with clients at the first meeting, one asset that they are often very concerned about is their pension, because often they will have contributed to a pension for many years, perhaps before they were married. But the law in this regard is very clear, again based on the underlying principle that I spoke about earlier. It is only the portion of the pension accumulated between the date of marriage and date of separation that is matrimonial property. And the same applies to any life policies which have a cash-in value other than on death. At your first meeting, your family lawyer will also ask you about how you're getting on with paying monthly bills if you're managing to make ends meet. And this is on the basis that you may be able to ask your spouse or civil partner for what's known as Interim Element. And this is monthly support to allow you to adjust to the separation where you have been financially dependent on that person. If you are going to be making a claim for interim element, then your lawyer will ask you for some detail about the money you have coming in and the money you have going out, and will ask you for some documents in that regard so that they've got that information for when they make contact with the other party's solicitor. The next step will be for your family lawyer to make contact with the lawyer of your spouse or civil partner, and the first step will be to agree the date of separation, because that is the date that the majority of the assets will be valued at. There are some exceptions, principally in relation to a matrimonial home which is owned in joint names, and that will generally be valued at the current date, but generally it is the date of separation that the assets and debts will be valued at. Your lawyer would also set out how you envisage the children being looked after, and will also make any request for interim element that has been discussed with you. Once all the valuations of the debts and assets have been obtained, that will allow the net matrimonial property to be calculated. The law tells us that that net property has to be shared fairly between you and your spouse or civil partner. Fairly will often mean equally, but there can be special circumstances justifying an unequal division in favour of one party. Special circumstances arguments can, for example, be where one party has used premarital assets to purchase matrimonial property or to reduce matrimonial debt, or perhaps where a party has given up a career to look after the children and the house and is now in the situation of re-entering the labour market at a much reduced salary than they would have been on had they not had that interruption in their career. The potential special circumstances arguments are, of course, endless, and at your first meeting, your solicitor will take detailed notes about your particular circumstances and will give advice as to whether there are special circumstances in your case that would allow arguments to be made for an unequal division. There will then be a negotiation as to how the matrimonial property should be shared. There's lots of options in this regard. The house could be transferred to one party in exchange for a capital sum being paid to the other. Alternatively, agreement could be reached that the house is sold and that the proceeds are divided in whatever proportions are agreed. Alternatively, perhaps if there are not really any assets that are liquid or potentially liquid, it may be that a pension sharing order is agreed and also some sort of ongoing monthly support being paid to the less financially well-off party for a period of up to 3 years in usual circumstances, but there can be exceptions to that. The hope is that the negotiation is then successful and that the terms of the agreement on how the property is to be shared is then recorded in what's known as a separation agreement. A separation agreement is a legally binding contract that's enforceable against either party in the event they didn't comply. Also, importantly, it ends the ability of each party to make any further claims against the other on the basis of their marriage or divorce. It will also bring to an end a spouse or civil partner's automatic right to inherit as a spouse or civil partner on the estate of the other party. Once the separation agreement is signed, then the only matter that requires to be dealt with, if you or your spouse or civil partner wishes it to be dealt with, is that of divorce. And generally, where you have entered into a separation agreement and managed to secure an amicable settlement, you will probably divorce on one of the non-fault grounds, which are 1 year separation with consent, or 2 year separation where you don't require consent. If you're the party raising the action, you don't require the consent of the other party in that situation. Accordingly, if you have separated, I hope this video has given you some useful information as to what to expect at your first meeting and what to expect from the law in relation to the division of your net matrimonial property. If I or anyone else in the family law team can assist you further, then please don't hesitate to contact us on the email address which will accompany this video. Alternatively, you can go to our dedicated family law website at www.btofamilylaw.co.uk and you can use our BTO Start tool to input some of your own circumstances and obtain some initial advice ahead of a first meeting with one of the team. Also, if there's any other topics that you'd like to see covered by the family law team in our video blogs, then please just let us know in the comments box below. Many thanks for listening.